Welcome everybody to our webinar on wills estate planning. I'll just give a few more minutes for some of the attendees to join us because we will start in 2 more minutes. But today you're in for a treat. I have with me today Grant Abbott, who has been in the industry for estate planning wills for a very long time now. And he's the partner of Abbott and Mourly. Obviously, a big change brings big responsibility now with the coronavirus. It is important to get your house in order right now. So without further ado, we'll start the webinar. So who is Grant Abbott? So I know Grant I've been attending to his presentations on tax, super and estate planning for over 5 years now, but Success Accounting Group has been working actively over the last 2 years, advising estate planning for our clients and wills and enduring powers of attorney. Grant has now has a law firm, and he's obviously the founder and partner, and with a Masters of Law. So he is the go-to person when it comes to wills and estate planning. And how to protect your family's wealth, especially in this time of crisis. So over to you, Grant.
Okay, thanks very much, Lan, and everyone for joining. This is probably only about the 10th time I've done one going out to mums and dads. Generally, I'll do webinars, and I'll have anywhere between 400 to 500 attendees, mainly accountants and financial planners, and in many cases lawyers as well. So I've kept this very, very simple for you, and covering a lot of the major issues that you may or may not be aware of. Importantly, with the coronavirus, obviously that's creating a huge amount of change across all of Australia and for that matter all around the world. And we all know people, whether they're in the US or UK or in Asia, everyone, I've got friends impacted everywhere. And when times are like this, it seems that we've been deprived of three things. One is that our economic freedom is obviously under serious threat, and how that plays out. I mean, everyone's dipping into their cash and their savings at the moment. The government's going to come out with some money for those people impacted. But everyone's impacted, and it's going to be interesting to see where we are this time next year. And I would expect that we'll probably be in a fairly sizable recession. Part of that also, that we've obviously got health issues as well, quite apart from the coronavirus, which seems to be impacting people who've got the flu or pneumonia, or got a weak immune system. It looks as though this is going to be around for a while.
The thing is, we've got 3 offices, so each one of us is.
Yes.
You just need to.
I might just mute, yeah.
So I'm in Manton office at the moment, so
Okay.
there's someone in.
Yeah.
You just need to mute them. That's all.
But the rest of the team is working for them.
How do I mute?
Go into participants, and you can actually mute everyone. Okay.
Yeah. Can I just a minute? Mute all. Yep. All right, Grant, you go ahead.
In relation to that, we've got our health freedom has been quite severely impacted, and we don't know day to day where things are going to go, and particularly if we're quarantined. And the Victorian Law Institute actually issued not a nasty, but quite a long missive today on how things must be set up, and if you don't get things correctly put away, particularly when you're dealing with banks, the government, superannuation funds, that effectively, if it's not in the right shape, manner or form, the only way you can redress a particular issue if you're desperate for money is to go to the Supreme Court. And unfortunately, with the Victorian Supreme Court out for the next 6 months, it's sort of put in abeyance. And so this disruption is not only having an impact on all businesses, but it's having impact on the legal profession quite profoundly. And the final one, of course, is that essentially most of us are quarantined. It's almost like being, I mean, we've got nice prisons, but effectively being quarantined is the last of our freedoms. It's virtually been taken away. Now, from our perspective is that when Lan first said, look, I've been listening to you and talking about wills and enduring powers of attorney and another thing called the protector, and that, I'd like to get it out to my clients. I readily agree, because the main thing is that we always think that these things can never happen to us. And then the problem about it is that history shows, and certainly the Supreme Courts and lawyers feast on these sort of things, that in essence, that even if you've got a will or you haven't got a will, then you're in a pretty bad position there. And I remember going back when I was 32, my younger cousin, who was 1 year younger than me, she effectively passed away. Well, she didn't pass away, she had leukemia, and her immune system was very low. They took her in for chemotherapy, and she didn't last the chemotherapy, and she was effectively died with 3 young children. Now, she died intestate, so the husband ended up with all of the assets of the family, including obviously the joint ownership of the house, her assets, which weren't significant at that stage. And then promptly within 3 months, I shacked up with the lady next door, who also had 3 children, and her children, or my cousin's children, were left virtually in a garage. Obviously the garage was updated for a period of about 10 or 12 years, and it significantly impacted their physical and mental condition ever since that time. So the fact that there wasn't any forethought or foresight, and particularly she was a nurse, you would have thought she would have been the first one to have a will and enduring power of attorney. So we've got to be extremely careful. There's an article there which I will send a link to with Lan. There was quite significant changes in 2017 of what happens if you die intestate. Intestate just simply means that you don't have a will. Then in that impact, you're going to have a very costly exercise as the public trustee generally comes in and administers your intestate estate, but it's got to go to the Supreme Court, and for that you're looking at tens, if not up to $50,000 in costs, in fact, to go through that process. So you're leaving behind a pretty nasty trail for everyone if you happen to be intestate. So what we want to do is this really brings an important note, and I do note I've got my legal partner Tony Anamoulis from Abbott and Mourly online. So thanks for turning up, Tony. But Tony and I have been working on these slides there for you, and these will all be available to you from Lan, as will this recording as well. So I wanted to also talk about this particular case, that even if we do have a will, first off, you have to have a will. If you don't have a will and enduring power of attorney in this current state of affairs, given the quarantining, given the economic threats that we're after, look, I can't guarantee it, but I can guarantee you that there'll be more people who'll die by suicide than there will from COVID-19 in Australia, and more importantly around the world, as the economies start to tank. So notwithstanding that, even if we do get a will, it doesn't necessarily mean it's all plain sailing. Under the Family Provisions Act in Victoria, any person, an eligible person, such as a former spouse, a child, if one of your children is with a spouse that doesn't really agree with your philosophy, or believes that your children have been left out or haven't been properly provided for under the will, grandchildren of the likewise as well, then effectively they can challenge the estate. This case here, which was Andre Taylor case, and you can see it on the right hand side, I've just excerpted something. This was out of Perth now, and as you can see there, it's on April the 1st, 2018. Effectively, we've got a Supreme Court judge has launched a scathing attack on lawyers who feasted on a small family estate with their indefensible legal fees, describing as a scandal that brings the profession in disrepute. Justice Jeremy Courtois' withering takedown was aimed at the lawyers involved in the case of Angela Miller, who was contesting the will of her late de facto partner, Andre Taylor, who left his entire estate worth about $600,000, which was only one property at the time of the three-day trial in October 2017, to his two adult children, Elizabeth and Philippe. In a recent judgment, it was revealed that combined legal costs were potentially more than $500,000 in a case involving 6 lawyers, one from interstate, but which should have had only 2, according to the judge. The small estate had been ravaged by legal fees, he said. The costs on this matter are not, as counsel for the executive described them, unfortunate. They are a scandal to the administration of justice and bring the legal profession in disrepute in the eyes of the public. Estates are not there to be feasted upon by lawyers, but go to beneficiaries and those who might be entitled under the Will, the Administration Act or Family Provision Act. And that's fairly important because it was only not what I would call a significant estate, but Angela Miller was awarded $240,000 by the court. But at the end, Elizabeth and Philippe shared the remaining $360,000. But at the end, none of them ended up with anything because the legal fees in challenging this court case, which went for 5 years, effectively wiped out the estate. So first rule of thumb from my perspective is, one, don't leave a will. The second one is the will that you leave, and I'm going to show you another couple of strategies later on down the track. The will you leave needs to be very specific, and if need be, you need to have some protection around it to ensure it goes where you want and not outside of the scope and the field of where you'd like to go. Particularly, you're going to hear me talk a lot about lineage and also bloodline. So I'm not sure many of you there, but how many of you really want to see your wealth dissipated through a family provision challenge so that monies go outside of your bloodline? And I would estimate that when I go and do talks to mums and dads, 99% of them say that they don't want to go through that case. So not only do we have to make sure that we do a will, but we need to make sure it's done properly. At the end of the day, what our skill is at Abbott and Mourly, and obviously with Lan's training and tuition and also mentoring, is to make sure that you put a moat around your family's wealth. And that includes not only your personal assets, including properties in your own name, but also ones that are sitting in trusts and ones that might be sitting inside your superannuation fund, which I'll cover over this session. So when we have a look at it, we've got our, we want to make sure that we don't have this, so that when the lawyers come and knocking on the door and trying to make a challenge against your estate, it's too late. They're going to move on because you've got a moat around your family's wealth. And you would have seen it in Melbourne, just in the local papers or online. There's always lawyers who will say they work for a no-win, no-fee basis if you feel as though you've been left out of a will or the will doesn't recognise your interest properly. Okay, so before we get there, we need to work on your enduring power of attorney. Now, enduring power of attorney, so this is essentially a power of attorney you provide to someone when you are alive. So we're not looking at the will yet, we're actually looking at now. So for example, you might be quarantined and effectively you're locked out, you can't go out of the house. Alternatively, you're sick, you're sitting in a hospital somewhere, and effectively you can't really make health or financial decisions on your behalf. Now, if you don't have an enduring power of attorney, then essentially you'll need the Supreme Court or someone of your family will need to go to the Supreme Court and be awarded a legal personal representative, which under current circumstances is probably not going to be worthwhile given the fact that Supreme Court's out for 6 months, except for really highly important cases, and would probably cost you $10,000 to $20,000 to do so. So the mere fact of getting an enduring power of attorney is really absolutely crucial. And it's not only for yourself, it should actually be for every member of your family. I've made sure that my daughter, who lives down in Elstonwick, she's only age 21, but I've got her enduring power of attorney. The problem is if she becomes sick or disadvantaged, then effectively what will transpire is that she may want to get that $10,000 out of her superannuation, you may well have heard, prior to 30 June. Or she may well want to apply for the job protector. The hard thing about all of these, particularly if you have a look at superannuation, you're going to need to show your identity. And if you're not the person, you need to show that you're their enduring power of attorney. Without that, effectively, those amounts of money, which are very time critical in dealing with banks and credit unions, dealing with the regulatory bodies, and most of you have probably been well aware that if you're dealing with any government body and you don't have a person's enduring power of attorney, you're not even going to get past point 1. But if you can show valid enduring power of attorney, then you are right in the ball game. So the enduring power of attorney has a number of fields. Unfortunately, if you've got an existing one, you may be very light on. In fact, your enduring power of attorney probably doesn't cover any family trusts you're dealing with, will not cover any companies that you're dealing with, and will also not cover any superannuation that you're dealing with. Generally, they look at in relation it looks at your health and generally your finances. So typically the enduring power of attorney, which you can just get, which you can basically just get from the Victorian government website under section 5, looks at your health and also your finances. But that's only the assets that you generally own, but it doesn't give you the power necessary to look over your bank accounts, etc. So as I said, you need to have a special enduring power of attorney that if you've got an existing family trust, you need to have succession in there. If you're able to look after that family trust, then you need to have your enduring power of attorney or a person called the appointor who's able to come and take control of that trust if it's yours. The same thing applies equally if you've got companies and you're a director. Your enduring power of attorney that you have, that you may well have stocked away in your safe or somewhere, does not enable a person with your EPOA, that's your enduring power of attorney, to become a director in your place. You need to have someone, an agreement with enduring power of attorney, a pre-signed authorization from yourself that this person, your enduring power of attorney, will be your alternate director. Otherwise, it's a complete waste of time. And for someone who's got a sole director company that's running a business, effectively in these sort of times, you may as well wipe that business out and just throw it down the trash can if you haven't got a valid enduring power of attorney. Likewise, if you've got superannuation, it's not too bad. If you've got a superannuation account with a retail or industry fund, then that's okay because they effectively take control. But at the end of the day, if you're trying to access your superannuation money, that $10,000 before 30 June and after 30 June, then effectively you'll probably be locked out if you haven't got someone who's got that enduring power of attorney for you. In self-managed superannuation funds, all members must be trustees of the fund, but if you have an enduring power of attorney, you can't just be a trustee of a superannuation fund. This SMSF, the self-managed super fund, there needs to be a special process and system, and also the EPOA that you have must have special provisions to enable you to act for trusts, companies and self-managed super funds. Likewise, the constituent documents for the trusts, companies and super funds must do exactly the same. As I said, all of those, and I've seen the case in a number of instances, all of those may just end up being flushed down the toilet, particularly if you have to make fast decisions on the sale of a property or fast decisions on the sale of shares in this current environment. Anyone who hasn't got an enduring power of attorney at this stage who's over 18 is in serious or potentially serious issues there. So first off is you need to have a look at all your financial structures, sit down with Lan. If you've got a family trust, if you've got a self-managed super fund, if you're involved in any company as a director, even if you're a shareholder, I mean, how are you going to go about selling shares if you don't have an enduring power of attorney? If you're locked away, you're incapacitated, you're hooked up to a ventilator, as I said, it's going to take you 6 months to go through the Supreme Court, $20,000, which no one can get to because no one has your EPOA, in order to have a legal personal representative. And so you need to go through and have a look at all those structures, what's in your own name, what's in joint names, do you have a self-managed super fund, do you have superannuation, do you have companies, and do you have trusts? The more of those you've got, the more you need that enduring power of attorney. So I would dare say 99.9% of enduring powers of attorney across Victoria are inadequate because they don't cover family trusts, they don't cover self-managed super funds, and they don't cover instances of companies as well. At Abbott and Mourly, we've built specialist ones that do specifically cover these particular issues, mainly because although we're lawyers, we're also tax and superannuation attorneys. So we know that the Companies Act and also, for example, self-managed super funds are governed by federal law. And again, generally enduring powers of attorney and also wills are governed by state-based law. And if you know your cases, if you remember the old Castle, which was made down, that movie that was made down in Melbourne, where Daniel Kerrigan took an action against the government for the taking of the land under the federal airports, that effectively was held to be unconstitutional, and they used the Tasmanian dams case, where effectively, if the government has got power to do something, the state acts can't override it. So again, the enduring power of attorney might be based on the state act, but we need to jump up a level, get to that federal level in order to make sure that we can cover ourselves in terms of companies and self-managed super funds. So you need to, at least if you've got an existing enduring power of attorney, send it to Lan to see if she's actually got the, whether it's all encompassing or not. If you don't have any companies or trusts or anything else like that, then you're basically A-OK. Now, importantly, is you'll see that in your enduring power of attorney, when you have a look at it, does it apply now, or do you have to be diagnosed with a medical or physical infirmity? Generally, you'd want it to apply now. The issue about that is that if, for example, you're overseas, and we dealt with some people in India who are locked down in their apartment over in India, and we need to make sure they got an enduring power of attorney for someone in Australia to act on their behalf. Because if they didn't, they were about to lose quite a substantial amount in a real estate transaction because they weren't here able to sign those documents. Now, they weren't sick, they weren't physically and medically enabled. It's just the fact that they were in quarantine and they couldn't be here. So when we have a look at enduring power of attorney, most of them, the ones that you have, are set up where they're based on medical and physical infirmity. But we need ones that are actually quarantine proof, so that if we're locked into our house and I'm here in Queensland and can't go down to Victoria, or you're a Victorian, can't come up to Queensland, that you can have someone up in Queensland and transact and enact for you. Otherwise, you're going to be in major strife. There was a large article written by the Law Institute of Victoria, which basically said you need to be in a position of either having enduring power of attorney for someone being in a physical position to sign any contracts or documents. Otherwise, you can't do it online, unfortunately. So we've got to be very careful about that one. As I said, all Australians over 18 must have an EPOA. So make sure all your children that are over 18 have a chat with Lan and come to an arrangement with her. She's super generous like this, but if you're going to do an EPOA for yourself, do one definitely for your parents. The hassle that it took, just from my own perspective, to have an enduring power of attorney and get mum into aged care was quite substantive. But now, unfortunately, I'm in a disastrous position because I want to deal with Centrelink, and I've got my father's enduring power of attorney and I've lodged that with Centrelink. But unfortunately, now dealing with Centrelink for my mother, who's in a nursing home in Adelaide, I've got her enduring power of attorney, but I need to get her to sign the Centrelink form, and then I have to take that into a Centrelink office, which is a lot of hoo-ha. So if you've got elderly parents, not only do you need to ensure you've got the enduring power of attorney, but you've also got the authorisation dealing with those regulatory bodies or the government bodies. And if you don't have the enduring power of attorney, forget about it, because you're not even going to be able to ring up on their behalf, and I guarantee that one. So EPOAs are probably the major, the strongest, the most secure and certain document that you need to act on behalf of anyone, because if you don't have that, forget about it. Okay, so let's go through. So we've got our enduring power of attorney, and we're going to look at wills, etc. Now, what we need to do, though, is not everyone we might have done an EPOA or enduring power of attorney a while ago, we might have done a will a while ago, but quite often the problem is people make a person an attorney or an executor, but then what happens if that attorney or if you're EPOA or the executor for a will, who is the person who looks after your estate when you die, what happens if they either don't want to do it, they're sick and disabled, or the worst case scenario, they're dead? Then if you have a look at that, there is no executor. Then again, we go back to that public trustee will come in and run it. As soon as a public trustee comes in, you might as well get rid of 10% of the value of your estate. That's essentially what they'll charge, and it takes months. And then on top of that, you've got another layer of family provision, because the public trustee is not going to fight as hard as your executor in order to preserve the estate. So they're happy to run out $500,000-$600,000 in legal fees compared to if it is kept in-house. Now, the classic line of succession that we want to have a look at is if we have a look at the Queen, and this is so opportune for the COVID at the moment. Remember, it was only a few weeks ago that Prince Charles was diagnosed with coronavirus. Now, the thing about that is you can see young Charles is sitting to the right of the Queen, but it's on the left in our picture. If Charles wasn't here, who would end up if the Queen died with coronavirus or was passed away and Charles was no longer there, who would be the next in line for the throne? That is the succession. Would it be Philip? Now, would it be, where's Prince Edward? See Prince Edward up there, you hardly ever see him anymore. Well, there's Prince Michael of Kent up there. Where's Andrew? Or they got rid of him. Looks as though I don't know if anyone can see, it looks as though, oh, there he is, Prince Andrew. Would he be caught in? No, it goes straight from there down to William. And if William was sick, then it ends up going down to George, who isn't even in that picture at all. So there's a very good, strong line of succession. And you can see that if something happened to Charles and something happened to the Queen, you're not going to have Andrew or Edward challenge William for the throne. It's got a straight line of succession. So we need to build that certainty into our own affairs. And this is probably the most important thing that you can do out of everything, is to work out, well, who is going to be my enduring power of attorney? Because whoever is generally is also going to be your executor, because you want the same person. If you think of them being smart enough, intellectually capable enough, financially aware enough, and more importantly, have a doggedness, because you do need to have a doggedness. As I said, when I dealt with my mum and Centrelink, unless you're in there and you're pursuing it, you don't want an enduring power of attorney, someone who's too frightened to get on the phone and look after your affairs. Now, if that person is ripe and ready and is really your pick as your enduring power of attorney during your life, then they should also be your executor, the person who's going to manage your estate after that. Now, the problem is, what happens if they don't want to, or they're not able, because they'll need to sign off as your enduring power of attorney and your executor under your will, that they're happy to take on that role. Now, it doesn't just have to be one person, it can be two. For example, we could have a position that is going to have a joint enduring power of attorney. But in the event that that line, that first line of power of attorney or that first line of executorship is not there, we need then to peel back and say, okay, who's the next in line? Who's the next person who's going to be dogged, certain, secure, and really going to look after my family's affairs? We don't want them to be in that case of that Andre Taylor where it's all frittered away in legal fees. You want someone to go in and give them a good bit of biffo up front, and certainly where Lan and Abbott and Mourly will be there on your side. So we want to be strong, secure, and provides absolute certainty. So that's a line of succession for you. Now, when it comes down to it, is that when we are building this, not so much during our life, but more importantly on our death, that our will actually provides for, the will can provide for a range of beneficiaries. You can put in anyone in the will. So, for example, I could put my good mate Tony Anamoulis in for the will and say, this, Tony's to get my property. Now, again, just bearing in mind, if I put that in, it may be subject to a challenge if I then left out my spouse and my children and gave everything to Tony. Alternatively, from that, we can be in a position that we lock everything in so that any bequest can only go to lineage. And lineage, of course, if we have a look at the Queen, lineage includes obviously Philip's out, Camilla's out, little Harry's in, Charles is in, what's the name, William's in. When we have a look at though, Prince Margaret, so it's Princess Anne, sorry, she would be in. But then when you have a look at all the lot at the back, effectively they would be excluded. So they come from Princess Margaret. So if we have a look, the difference between lineage is all those people who are directly from the Queen, and then we have a look at bloodline, which actually would include all of those people, anyone with the same DNA strands as the Queen. So when we're building these, who do you want? Do you want your lineage or do you want your bloodline? I would always say that if you're looking at leaving your assets, your wealth, your family heirlooms and jewels, that it goes down to lineage first. And if there's no lineage, because they've all been killed from coronavirus, and just don't think that this is going to be the last virus around. It's a wake-up shock for all of us. But it wasn't that long ago when it was SARS, and then there was MERS, and there was the mosquito virus. So it seems to be coming around more and more regularly, so that we've got to be very careful about that. If it does wipe out lineage, do you then want to go to bloodline, and which bloodline for you? So the important thing is, who is your line of succession? And as I said before, who's the person who's your EPOA? And is it just singly or is it jointly? And if they're not around, who's going to be the next in line? So, for example, if I have a look at mine, I've got my eldest daughter, who's a part of my line of succession. She's also joint with also my eldest brother. Now, if something happens to one of them, then it falls responsibility to the other one for my enduring power of attorney. The next in line is then my other brother, and also my current spouse, because they've been married before. So they fall in the next in line. And then if they're not around, then the final one, it goes down to my other daughter. So when we start to look at that, we've got a line of succession, and that also can apply through your executorship as well. So the line of succession is the first line is who acts as EPO and executor for your estate when you pass. If they're not around, there's the second line and even the third in line. As we said, when we went back and had a look at this picture, we've got first in line Charles, second in line we've got William, third in line is George. And then if George is not around, I think it then goes up to Andrew and then Edward. I'm not quite sure about that. There's only so much succession of the royal family I can handle. Now, if there is a joint, who gets the final vote? Because it's not much good if you're looking at selling an asset that's in the estate or the enduring power of attorney if they disagree. So one of them has to have a binding final vote. Now, what I would suggest that Land is going to be sending out a data capture, or alternatively you can go to Land that does a data capture around both your enduring power of attorney and also your will. In that instance, we go through and ask you, what is your line of succession? out of everything, your line of succession is absolutely crucial. And feel free to either give Lan a call, or you can contact Tony Anamoulis at Abbott and Mourly, and Tony will be able to take you through that as well.
So sorry, yeah. Grant, just to interrupt you. So our data capture form has been uploaded on our website. So you can go there now and just there is a link provided on at the end where you can find that. So okay.
Fantastic, and I think it's absolutely crucial for everyone looking at this is at least get your data capture. If you do nothing else, you don't go ahead with something, at least see and leave some sort of wishes, so that although the public trustee isn't going to take it into account, but at least someone knows that you were thinking of them, albeit it's probably not going to work out very well for you. So who's your line of executors? As I said, they must be strong and able to face up to any challenge. Lan is going to be by their side. The last thing you want is a grandchild or someone attacking your estate. And I've got some really good questions at the end. We'll look at FAQs about overseas properties, etc. Now, is your will to be a simple will? So the way it works, and the best way to look at the wills, is first off, get your executors, get your succession line of executors, then decide. You don't lump everything together. You're better off giving specific gifts. It's like anything, something specific overrides a generality at law. So, for example, if I say that Tony is to get my Mercedes Benz and I give the license plate number, then that effectively means that the executor will come in and say, okay, well, this is a license plate, and then we'll transfer it over to Tony. The fees and stamp duties and any taxes we need to limit or list inside our will, and it's all done through that fact find. Lan can do all that with you, and we check it off at Abbott and Mourly. That when it goes through, is it to be paid by the beneficiary, that's Tony, or is it to be paid by the estate? And generally, it's best to be paid by the estate, the same as funeral expenses. If we look at that, generally funeral expenses are paid by the estate. Now, with personal effects, quite often I'll find that people don't like giving personal effects, or it's just too much. So sometimes it's better just to let all your personal effects, your executor choose them to be distributed, or the personal effects to be distributed across your family or your bloodline, or better still, remember, your lineage, on a fair and reasonable manner. So again, specific gifts are the best. Once we do the specific gifts, we've paid out all taxes in the estate, paid out the funeral, paid out any debts that are owing by the testator or the deceased. We pay out all our specific gifts. Then whatever's left, the remainder of the estate, which is called the residual, goes to the main beneficiary. Quite often that may be the spouse. It might include the spouse and the children. And we can write down there, for example, we could write in there that's to be split between the spouse and the beneficiary. Each one's to get 25% of my estate. But if you're going to do that, if you're going to write down the spouse to get 25% of the estate, it's best to make that as a specific gift rather than as a main beneficiary. Remember, this is the back end of the will. Specific is better, the back end of the will. Superannuation, all my superannuation is to go to my children or to my spouse. Specific gifts first. Otherwise, if it's not covered by a specific gift, it goes to the main beneficiary. Now, if the main beneficiary is not alive, then it goes down to the person who is your residual beneficiaries. And quite often that may well be the children or the grandchildren. But you need to specify, is it going to be children who are of your lineage and your bloodline, or is it going to be any children, for example, adopted children, or is it going to be stepchildren? Are they included? So we need to start to go into that side. But that's essentially a simple will. Now you'll find in the simple will that Lan uses, it also includes what you want to do with your funeral. You know, do you want to be cremated and your ashes being thrown over the Royal Victorian Golf Club, or thrown off the jetty at St Kilda, or taken up to the Dandenongs? It's essentially going to be up to whatever your wishes are, and your executor will fulfil those. Even with pets as well, particularly if you're the last surviving pet owner, who is going to look after the pet? And more importantly, Are you going to leave any money to look after the pet? For example, 5 years of pet fees plus pet insurance might be left there. The same way for those of you who've got children that are under 18, there's also child guardianship. This is all in the basic simple will. Now, if you have a problem that, as I said before, states can get messy and expensive, particularly if you've been married before, because any of your prior spouses can make a claim on your estate. There was a case in Victoria only recently where the lawyers, and remember these guys are no win, no fee, so once they get one beneficiary to attack the estate, they'll now go out and look for as many beneficiaries or potential people who are able under the Family Provisions Act to make a claim. It becomes a virtual class action against your estate. So once you do that, that's at least $100,000 plus, and you can see up for that $600,000 estate in Perth, it adds up to $500,000 or more. So in this case, what they did is the individual, the deceased, had been married before. In fact, had been married 3 times. The second marriage was to a Filipino who he brought out to Australia for a year, and then the Filipino went back to, his Filipino bride went back to the Philippines. One, for a couple of reasons, is that he found out that she was already married. So his marriage was effectively annulled, but she still had standing under the family provisions to make a claim against his estate. So you've got to be very careful. And it's also your children. It's not necessarily who your children are, but more importantly, who they're involved with, who may get them involved with a lawyer who's going to make a claim. And once they do, then it ends up being a class action. Now, we can help things, because if we have a look at it, if any of these apply to you, then you're probably going to need something more than a simple will. And it may well be a will with a testamentary trust, which I'll go in shortly. So if you're getting married in the future, you probably need to have more than a simple will, because you've got to think about your future children that may pop out of that. Or if you're already fairly senior, getting married for a second or third time, you absolutely need to get something strong to look after your lineage and your bloodline. If we then go down, if you're separated but not yet divorced, absolutely you need to have a more stronger will. Do you have an ex-spouse? I talked about that. Now, some of you family members, you looked after them during your life, or effectively you don't want to look after them in your will. That means that there's good chance there's going to be a challenge on your estate. In fact, it's absolutely guaranteed 100% there will be a challenge. And the ones who win the most out of all of this is obviously the lawyers. Now, you can't imagine that any lawyer would work for nothing. And I'm sure my friend Tony would talk about that. They don't work for nothing. So when they say no win, no fee, they know exactly what they're going to get into. If they can stretch out a family provisions claim for 2 or 3 years, that's a lot of money that will be paid from the estate. As I said, we've looked at what's 90% of the estate being ravaged by legal fees in that Perth case. And that's not the only one. There's been cases around. There was a very, very famous case in England in the year 2000, and it ended up being challenged for 20 years. The size of the estate was £20 million. And as you can imagine, that was quite a sizable estate in the year 1900. But after 21 years it was, the whole case fell away because it had all been ravaged by legal fees, going up to the Privy Council, the House of Lords. So it's fight upon fight upon fight. And for those of you probably well aware, the most famous estate planning and trust cases have been with Lang Hancock and Gina Hancock, and the fights of her children, Lang's grandchildren, who've been set up in a testamentary trust. But unfortunately, it was set up very poorly, with Gina Hancock taking full control of that trust and denying any benefits going down to the next beneficiaries. So again, we've got to be very careful about that, and those challenges come thick and famous. That would easily be $1 million or $2 million legal fees in that case. If you've got some of your children or or brothers or sisters you want to look after if they've got mental and physical incapacity. So it's not a bad idea to do a disability trust. Marital problems, bankruptcy issues, or big spender, then definitely you want to have a testamentary trust there. Again, if you own a business or shares in a family company, the same thing, that things can happen in terms of the enduring power of attorney. We need to be very specific exactly what happens inside the trust or the company, or even your self-managed superannuation fund. And if any of your beneficiaries live overseas, again, we need to be very careful about that. So we move from the simple will into something a bit more sophisticated. So that includes special drafting, or more importantly, quite often we use a testamentary trust. Now, a testamentary trust is a trust that springs up out of the will. The benefit there is we have a trustee, and the trustee, generally the first trustee of the trust will be an executor, family member, or beneficiary. So, for example, my youngest daughter is a big spender, or what they call a spendthrift. So any monies that I'll leave in the estate to her will go into a testamentary trust for her. She's 18 years of age. There's no way in the world she's going to be the trustee. So the executor of my estate, which remember is going to be my eldest daughter and my eldest brother, will then be trustees of that estate. It'll go into this testamentary trust. They'll invest it. They'll have full power to invest. And then what will happen is I can leave that trusteeship until, for example, she's age 25 or 30, and then it can switch over to being her trust. So she's the beneficiary, or the sole beneficiary, but I can make a choice. Will I include her future spouse? No way. So I can exclude her future spouse. I can then ensure that it's only for my bloodline. So then any benefits coming out of that testamentary trust are localised to my bloodline. If there's children, if I've got younger children under 18 to be looked after, there's also significant tax advantages because there's no penalty taxes applying for them. So testamentary trust could be disability trust. It could be just for superannuation, but certainly we can either be discretionary on the monies coming out, or we can put in some fixed entitlements, such as income that can flow out to my daughter, for example, and any of her children, but she can't take any capital till age 25 or 35. Or I have seen ones where they're not allowed to take capital at all if they remarry, or if they marry, which has been quite interesting, some of the really old trusts that we've been involved with. So that is what a testamentary trust is. Now, super does not form part of the will because it's governed by Commonwealth law, and so state laws don't look after your super. There's been a couple of cases on that, Donovan and Donovan, and also the tax office got a ruling on that one. So if you've got a retail or industry superannuation fund, then you can bind the trustee. So you do a binding death benefit nomination. If you haven't done one of those, then I strongly suggest that you contact Lan so she can look after it. Now, the danger about it is if you pay it directly out to your children or your spouse, that's not a bad thing because that won't be contested at law. However, what will happen is it can be contested under the Superannuation Tribunal, which is under the Australian Financial Complaints Authority. So that's a no-win, no-fee basis. So if you're an industry or retail fund, you're sorely up against the wall with the guns firing on that one. Alternatively, you can also always transfer it over to the estate, and then it just becomes part of the estate. So you can go through a specific gift or main beneficiary, or put it into a testamentary trust, your superannuation, for the benefit of whatever beneficiaries you are. And you can have multiple. So when we go through here, your testamentary trust, you can have like 5 or 6, one for each child, which is quite common if it's quite a sizable estate. Now, with that one, if it goes into the superannuation estate and it's solely for one testamentary trust, we call that a superannuation proceeds trust. Now, in a self-managed super fund, again, we've got a lot more protection than we would have outside. So we can do what we call an SMSF will, and that's a set of binding directions on the trustee of the SMSF, and effectively we can give out income streams, we can give out lump sums. So, for example, with my daughter, there's no way in the world that I would pass the money through the estate into a testamentary trust if I can provide her with an income stream on my death that carries until age 25 when she gets the capital proceeds. The reason I say that is because that is tax-free in her hands. So there's a lot of exciting opportunities again if we have a self-managed super fund. But again, we've got to make sure that any estate plan we build for it, an SMSF will, has to be for lineage or bloodline. As I said, we can transfer the estate, but that's not my preference. One of the other things is you can see where we started off right earlier. I'll just go back, and one of the key things here is to put a moat around things. Let me just see, I've got the moat. So when I go through and have a look at my moat there, as I said, we've got the lawyers will always, and not only that, but government, and through our life, people are going to be attacking our little castle. That's just the very nature of them, and particularly living in the litigious society we live in. And can you imagine, out of this COVID-19, how many legal suits there will be for people failing to pay rent, or there'll just be so many small legal suits of people. If there's not, generally, if there's a good contract, we'll have a force majeure clause in it, such that such as thing as a pandemic will override and cease the contract. But if you haven't got that, your contract still takes full force. So that's a very dangerous position, and we need to, one is get ourselves into a moat. And the best way of doing that is another thing that really gets around a lot of this sort of stuff. So the way we do that is we use a thing called a protector. Now, a protector is a special tool, and what we do is we set up a lineage or a bloodline trust. So what happens is that if we're setting up for you and your spouse, you guys would be the trustees and the controller of that trust, but the only beneficiaries are yourself and anyone who is your lineage. Remember, those people underneath you. And if there's no lineage, that goes out to your bloodline, which include your brothers, your sisters, your parents, your cousins, second cousins, aunts and uncles. So we want to keep it pretty close to the lineage. Now, what we do is we determine all the equity have in all our investments, whether it's our personal home, our jewelry, gold, art, motor vehicle, share portfolio, and all our properties. We don't care about the properties ourselves. What we want to do is find out how much they're worth, take out any borrowings or any loans that we've got. So at the end of the day, we've got what we call a net equity position. So what we're going to do is get that net equity, and I'll show you shortly, we're going to gift it over into a trust. Now, this is absolutely important for litigation. Government's taking action against you. Again, if you've got no assets, then the government's not going to take action against you. Again, if you've got no assets, you really can't be attacked per se, because what can you do? What can you give to your creditors? You just got to be very careful, because you're gifting over assets, that your trustee in bankruptcy can go back 5 years and pull back this gift. But look, if you've got no real concerns at the moment, go ahead and build a protector for yourselves. The best one, though, is estate planning. Is that, remember that challenge, that Andre Taylor case. If at the end of the day, you've got all your assets sitting in this bloodline or this lineage trust for your family and bloodline, that's the best place for it. So that you know when no fee lawyer's going to come in, start rooting around all your assets and finding there's nothing there, then they're certainly going to bypass that estate pretty quickly, because they're not going to do a no-win, no-fee for no fee if there's no assets. Now, what we're doing is we're transferring equity, so there's no capital gains tax and no stamp duty. So you still get use of the properties, the jewelry, the gold, the art, the motor vehicles in share portfolio. They're still in your name. When you sell them, there'll be a capital gains tax liability, but effectively what will happen is that equity will be topped off or undersold. So you still have the assets, and that's by way of a loan agreement or a hire agreement. But at the end of the day, you've really done well if you have no assets to fight over. So as you can see here, step one, and again, I'll get Lan to put up a data capture for the protector up on the site. So you work out your net equity. Remember, this is my home might be worth 2 million, but I've got a $900,000 loan on it. So that means my home is worth 1.1 million. My investments, again, we've got to take our liabilities off. So my net equity is $1.7 million. That's step one. Step two is I set up this family protection trust, which is a bloodline or lineage. It's only for family beneficiaries. And I take this amount of equity and I gift it over to this trust. And then the trust then lends it back to me. So I can still utilize those properties, but there's a charge over all those assets. So at the end of the day, if I die, then effectively all those assets, or the executor is going to have to transfer all those assets or sell all those assets and repay the loan into the family protection trust. So before you get to specific gifts, before you get to the main beneficiaries, everything ends up going into the family protection trust. And so that's the strongest position for the executor, because they're not going to be challenged. So let's go and have a look at the final few FAQs, and then we'll go through to the next steps for you, and then we'll have a look at that. So the husband and I have overseas properties. Can I put those properties in the will created in Australia, or you need to have a will overseas for those properties? Absolutely, you can look after all those properties. In fact, it'd be crazy not to put all those properties in there. But you need to empower your executor to ensure that those properties are transferred over. However, each jurisdiction, for example, over in Greece or Italy or wherever, you might find there's family provisions claims made on those estates or those properties over in the different jurisdictions. Again, use the protector, but if you do have properties over there, just be careful of the estate planning laws or the family provision laws over in that jurisdiction. So, can we appoint someone to look after our properties until the youngest kid turns 18? Absolutely. Remember, these could go into a testamentary trust. So your executor is looking after all of the properties because they all go into a testamentary trust, and none of your children become trustees. They receive income, but they're not able to get income or capital until the youngest one turns age 25. What happens if the appointed person cannot act on our behalf, such as they've got a case of disabilities? Again, this is where that succession planning comes in place. If that person's not available, it goes down to the next one and the next one. So there is always going to be someone there who's going to take control of your wishes. What would be the best arrangements to protect the kid's best interest in case we're not here or here, but not in our clear minds? As I said, the best one for me is, remember, that family protection trust, and we can set that up now, set that in place now, put limits on how it can be looked after for your kids, when they can take it, whatever. Otherwise, we go into our estate and we do exactly the same around our testamentary trust. If you don't want them to take the capital until age 35, absolutely tell them. If they get remarried, they're not allowed to take the capital, absolutely, if they want. The only beneficiaries can be their children that are of your lineage, so your DNA, and so it doesn't include the stepchildren of any future spouse they have, absolutely. So you can put all of that into those arrangements. What are the charges to get the wills done? Well, it's going to depend on whether you've got a simple will or if you've got a very more detailed will, but it's not an expensive process, and have a chat with Lan around that. You'll need to go through your data capture first. She'll look over it, and she'll look over any trusts you've got, any SMSFs, and also you need to do your EPOA as well, so you combine both of them. Lan will then have a look over that, and she'll be able to give you a quote. And if need be, in some instances, if it's a very difficult case, then Abbott and Mourly will come in and we can spend an hour with you. So that will save a lot of costs if we can only spend an hour with you, and we'll look at all the information that Lan has provided to us and be able to build it very quickly. The good thing about our system is we use the most advanced technology around the world in order to make things as efficient as possible. So not only are you going to get the best wills and EPOAs, taking into account succession, the protection, etc., but more importantly, it's going to be safe, certain and secure for yourself and also your family for generations to come. How are the wills executed? Well, if you have a look at that, you'll find the best one is to do it in person. And because you're down in Melbourne, Tony Anamulis, our offices are in Little Collins Street. So the best thing to do is you'll be able to do it with him in person. But more importantly, you'll find when you do a will, there's a whole execution sheet that Lan and also Tony can take you through from that perspective. If we have a look at it, and then you can limit anything to kids. If you want to give the kids one property and tax, who's going to pay the tax? Again, is it going to be the beneficiary or is it going to be the estate, as we looked at before? So just in closing, your next steps, complete the data capture, and that's for an EPOA, enduring power of attorney, and also for your will as well. For those of you who really want to protect and do that family protection, use the protector and you'll be able to get that data capture from Lan as well. If you're doing a will, remember specific gifts first. Get rid of everything by a specific gift before you go to your main beneficiaries. It's a lot more safe, certain and secure. You'll find here that there's a whole lot of stuff around the EPOAs, so you'll be able to get your data capture there. Now, do now, not later, because again, last thing you want to do is intestate or something happen. If suddenly you've got a cold or a fever and you're laid up, you don't know whether you've got COVID-19, who's going to manage your accounts, who's going to do everything? You know, even your spouse can't necessarily do that without an enduring power of attorney. Make sure your kids over 18 have it, just in case you want to access their super. I think personally, being any child under 40 who's able to access their super, $20,000 would be crazy not to, because they're not going to be able to take it to age 60. Why not take it now, use it to pay off a mortgage or use it as a deposit for the house? A 45-minute Zoom meeting and advice, estate planning strategy with the most appropriate will for you. So Lan will go through that process, and then once that's all done, then what we'll do is we will then effectively, it'll come to Abbott and Mourly, and then we'll look at what Lan has produced on your data capture, and then we'll work very closely with you to get execution and sign off. So book your appointment with Lan. Do you want to go through that last bit and then wrap it up for us, Lan?
Okay, so before I wrap it up, please, if you have any questions, now's the time to put in the chat. We have a few minutes for the questions, but basically to explain, we, as your accountants, we know your financial situation very well. So therefore, we will, you know, after receiving your, your completed data capture form, we will sit with you in a Zoom meeting, and then pretty much prepare and draft the will, but have Abbott to sign off on it, so that you get the best of both worlds. Because most of the case, when you go to your lawyer, they not necessarily, or to a lawyer, they don't necessarily have the full financial picture, which we would have. So you'll get the advice from, the tax side and the financial side, as well as obviously Abbott and Mourly to sign off on the legal side. So that's why I invited Grant today and Tony. If you do, at the end of the meeting, everyone who's registered for the webinar will get a link to the capture data form. But yes, I thank you. I'll just have I think I have one. When we establish a trust, we have a succession plan in the trust deed. How is that different from having it a will? So, Grant?
Yeah, so it depends on whether you're doing the trust now versus if you're doing that protector, remember we're doing now. So we do that, we put the succession plan in the trust deed. It's going to be much the same as the will. The smart people, and this is a really good question, is if you've done your succession plan, you've got your enduring power of attorney. Remember, you've got your first line, your second line, your third line. Likewise, for your will, you have your first line, second line, and third line, which are exactly the same. Now, when it comes down to a trust, you have the same thing, is that if something happens to you, then the person who's your EPOA, who's your executor, is the next one to take control of that trust. And you can even do that with a self-managed super fund as well. So that's what building a MOAT means, is you're actually looking at all your structures and you've got the whole of succession matches, so that those one or two people have complete power over all your structures. And then if they get attacked in any way, shape or form, they can repel the attack as best as possible. So that's a great question. And again, it just shows you, when you go and see an estate planning lawyer, as Lan said, the lawyer will just look at what you've got in your personal estate. They don't look at the other structures. They don't look at the protection. So they don't look at that detailed succession, and more importantly, the tax consequences of that as well.
Okay. If there's no other questions, oh yeah. So when we said we have a succession plan, yep. Same thing applies to SMS when we can get up. So I think we will take, yeah. So anyone else to have further questions, please email directly to me, because that's all we have time for now. I've just noticed it's already 1:35. So, but thank you very much again, Grant and Tony, for taking this session, because we wanted to get your view, because you know, on the legal side. And I agree that a simple will is simply not enough these days. So you need a tailored will. There are different wills that obviously the more specific it is better for our clients. And consider the testamentary trust, because that also allows you to you know, have more flexibility in the way, the tax implications in terms of how you distribute the assets. Yeah, finally, don't delay. A will is important. Do it now, because, you know, now is a, I mean, I've myself talking to Tony this week about updating and reviewing my wills, because, you know, you might have got a will when, you know, 5 years ago, when you had, you're not, you know, you didn't have kids and not have an investment property. But how often should people review their wills is the last question. And when should they update their wills?
I would say for me, here's the thing: if you've set it up properly and you're looking after your lineage and your bloodline only, every time there's something that happens in your family, you need to go back and say, well, oh God, you know, my daughter's now going out with this reprobate or this kid who's absolute nightmare, and I'm giving her too much control. I need to peel that back and maybe put it into a testamentary trust, or effectively go back and just tweak a little things, because you can always tweak things. It's like a recipe, and then you can change a little bit later on. So it's absolutely crucial to look at it at all times. But as I said, it's not, for me, not only is the will important, but that enduring power of attorney is probably the most important document at this stage, when we're right in the midst of COVID-19 and we're locked down for quarantine purposes. Imagine if you're on a cruise ship at the moment and you're trying to do something.
Yeah, that's right. And that's why the timing of this webinar, I think for the last 4 weeks, I've spoken to nearly, you know, hundreds of clients that either don't have a will, or have a will that's in place 4 or 5 years ago that never been looked at or even know where it is, and definitely don't have the updated EPOAs, and definitely don't have the, you know, the appropriate I guess strategy to protect their assets. So if you're one of them, please come and speak to me or one of my team, and Tony and Grant is also here to help as well. Okay. So
if you're in that position, you haven't done anything, I'll tell you who's going to be very happy. It's the Lawyers Benevolent Fund. So the lawyers will love that one. So again, we want to make sure we get all these documents so that the lawyers and the government and all that can't take control of it. And they will try to. You don't have this much money being given away. It's nice at the moment for all this money to be given away and for us to go into $1 trillion in debt, but someone's going to have to pay for it in the future. So just have to watch out for that one.
Yep. And finally, if you do have a will that you think that may not be appropriate, we're happy to have a look and review it to see if it is appropriate. Is that something that we should offer them as well, Grant?
Yeah, absolutely. Yeah, absolutely. It'll only take a second to do that, so you'll know straight away. But particularly the EPOA, you'll know straight away, because you know all their trust and financial affairs. If it doesn't include that specifically, then there's a hole there. Now you can keep that existing one, but you might need to overlay it with a specific one that looks after trusts, companies and superannuation, so they sit side by side, which isn't a bad thing.
Okay. Again, thank you everyone for joining us, and yeah, we look forward to reviewing and updating your wills. Okay. Thanks, Grant. Thanks, Tony.
Bye.